First of all, thanks to everybody being here, all our national reporters, and we started with this initiative last year to have a well a yearly kickoff for the yearbook, also to see you, albeit online, because as is clear from all the time zones that we are tuning in from, it's very difficult to bring this group together because it's a really global project. But still, it's I think nice to have a sort of touching point with the coordination side, Chris and me, with the academic side with Professor Pistone and Baker, so that we have a sort of a first view of each other before the project starts. Last year we started actually what instigated to for us to have this now it's called a dialogue is actually that last year we had a significant change, which I want to reflect upon a bit, maybe sort of evaluate it from our side, from my side, how that went, to sort of show you as well where we want to place a bit more emphasis in the reporting, where we can be of more help for each other, and also obviously to ask questions, to have a dialogue on this. Actually, last year the opening slide did not say dialogue with national reporters, but briefing to national reporters. That's a bit top down, I would say. But now actually there has been reporting on the new aspects, and therefore I think it's good to reflect on those. And I think what we could see in general, so I'm talking specifically about section 13 now, because that was the AI and the AAS, so the artificial intelligence and automatic or automated systems section, and that was new. And I think we could see that in the reporting, because always when you start with these, it's difficult. And I wanted to highlight a few aspects more from a data collection point of view. So from our side, to increase the content or the value of the content, and also to acknowledge, I guess, altogether, perhaps, that this is difficult because we're doing something that you don't see a lot in legal scholarship, and then we are doing that in a field of legal scholarship which is actually completely novel. The field of digitalization, decisions not being taken by humans, etc., etc. This is, like I said, the differences were quite wide, and therefore the sourcing also was quite varied. And I think the sources are the backbone of our project, or at least they try to validate scientifically what we do. And therefore, I think with this different subject matter, as I will show at the end of a few examples, we have a few, I would say, difficulties or challenges when we are looking at sources. And another aspect, I think, is, and that's more a general theory of law kind of idea, is that usually the administrative parts of tax law that we're dealing with are and that surface in this project are part of, for example, a constitutional framework. And a constitutional framework tries to sort of encompass all the relationships within a state. But this is new ground that we are breaking. So you see that sometimes the legislation is not there, or like I say in the final bullet, the situation is not applicable. So I just wanted to highlight this not applicable, this option of not applicable as a very valid option, and also a very valid scientific output in this sense. This is not a ground where we're looking for a yes or a no always. Actually, not applicable is a very viable option. And then, like I said, I wanted to take a few of the pie charts that Chris generously composes every year to show a few of the difficulties I think that we all encounter, and some parts we might have a dialogue on, also to give an idea of the difficulty from our side in getting the data that we collect up to a certain standard. So this chart 85, the question is, are taxpayers who are subject to a tax compliance procedure that involves AI or AAS informed of that fact? And here, I think this is a classical example of a difficulty for evidence and fact finding, because how would you know? For us, the gold standard here is a law which says in the jurisdiction, if you use these systems, you should tell the people. However, I think in reality, we see that if these systems are used, even if they are used, because you can see not applicable is 55%, then it would usually be, or even on a lower level. So it would be more on an administrative guidance or whatever. And then already you see that it becomes more tricky. Then on an even lower level, the information, um, or the information of that goes to the taxpayer that this is a procedure with AI or AAS, sometimes can even happen within the return process. And how do you report on that? So I think we're seeing these difficulties, but I think this year it would be good if, for example, you know that this happens within the procedure. If you're, for example, notified that your tax return has been, composed with these with automated systems, that could also merit a note in one of the boxes that we have when you are filling in your response. And chart 86 is asking in communications between a tax authority and a taxpayer that employs AI or AAS, is it stated that they are represented only by machine? And here we have a difference or a difficulty, I would say, with the types of communication that we see. Because if you're talking to a chatbot, does it say, or does it first of all have a chatbot, the website of the tax administration, and then does it say upfront that it is, an automated system like it does with, for example, companies? And then also, is that saying that it is an automated system because there's a law that says so, or simply because it does so? So I think there it is quite difficult, and also again a high score of non-applicable. But there's again different categories of communication. We can say the same actually of an automated system can be a reply email. So for example, if I send an email to tax, I'm sitting in the Netherlands. If I send an email to tax administration at the Netherlands.org, and it tells me, well, this is our general email, you would get a reply or an automatic reply email. So I think the categories are also difficult here, which again I would like to stress asks from us, I think, in the reporting and in the data aggregation or to make sure that we encompass as much as possible, and then later on we can sort of cut it back. Then chart 87, another example, I think, of some of the challenges that we saw this year. If a decision relating to tax administration has been taken by the use of AI or AAS, is the taxpayer provided with basic details of the procedure applied? And here again, those basic details, where will we find them? And this is again a question of sourcing. And actually, the sourcing question is highly relevant because it will show us if jurisdictions put this in the law because they prioritize and see this as a part of law, or if they have a guidance from the tax administration or a general guidance from other organizations within the government that deal on a more general level with digitalizations, etc. So here again, we see wide variety. Obviously, the group of reporting is quite low. However, as we see that tax administrations are making more and more use of these systems, we will see also more variety. And again, we encourage you to report on that variety. Then for the two other, or here I'm putting two systems or two charts next to each other. So we have chart 89, which asks, does a system exist for voluntary registration of AI or AAS? And chart 90, if yes, does the tax algorithm, tax authority register all of their tools or algorithms within that system? And I think here I wanted to put a bit of a clarification to this specific one, because here again, we are talking about, I think, differences between general systems and specific tax norms, because generally states, or at least I know quite a few states currently still flagged in the no category, which we actually intended to catch within this category, or at least which are moving towards this yes category, because from a general perspective, so from the general Ministry of Digitalization, this might be a priority, which then, of course, does not really has reached the tax world, but we're probably going to see quite a few changes also in this respect. Then on chart 91, the question is, are decisions that may have a significant impact on a taxpayer taken exclusively by artificial intelligence or AAS systems? And I think here also what is difficult to assess, but still we would like to have your input on in the sources section is, how do we assess this? What is the division of the burden of proof? Does the government actively tell that they're using the systems exclusively, or do you have to find out yourself? These kind of things are also interesting. So I think in general, like I said, that this is also an encouragement to use that box. Also, if you have different things to say, which might be a few lines, we might get back on it if we think, oh, this is something we need to pick up on. So activity or actively reporting on this. Also, if you have questions, put them in those boxes, and we will assess that and might come back to you. Then chart 92, if decisions impacting a taxpayer are taken by AI/AAS, are they overseen by a suitably qualified individual before the decision is notified? And here also we're getting into a discussion of what is suitably qualified. Is that somebody qualified from a tax perspective? Is that somebody qualified from a data protection officer perspective? So there's also, again, I think there might be instances in which you are reporting and you might not be entirely sure. And also, again, here I would like to stress, we are there. You can use the box with sources and say, okay, maybe I'm not entirely sure, but look at this document and look at this, and then we will look at that. So I think the overall spirit of this small presentation of mine, or small part of this webinar, is that this is a cooperative exercise, and that we are here on the backside, not only to give you questions like, oh, please, because I think most of you must have had those questions, please give us a source, give us a link, give us that, but we can also have a bit more of a dialogue in that sense. I think 97 is actually a bit of the same. So a senior official with overriding responsibility. Who or what is that senior official? How do we identify it? Again, if you want to talk to us, use the Google Forms for that, and we will be happy to do so. Yeah, I think that, again, to sum up, the reporting is really developing as we are, or at least the field is developing as we are reporting. And in general terms, it is moving from secrecy on use, or at least it has been first, the use has been implemented before the legal framework that should supervise that use, which makes our work in this respect very interesting. But that also makes it a bit difficult, because sometimes I think you might be feeling like a detective looking for guidance notes that we are asking, or looking for one of the categories just mentioned. And I think it makes it interesting, but also still a challenge. And I would say that I think in general terms, what we've seen this year in the reporting was very good, and also showed and highlighted that there's a lot to do. And I think one of the main, or one of the most interesting aspects will be now that we were getting this year a second wave of reporting on AI and AAS. And therefore we can start comparing, we can start see trends of adoption, of scaling back. And I think that that will be extremely interesting. Then that was the the interesting part, one could say. But now I have to do some housekeeping also for Chris, but also to make, I think, everybody's life a bit easier in this process. As you can see, well, the questions, and this is also for the new reporters, obviously. The questions that we have are 2 or 3 tiered. You can see the minimum standard or the best practice, and the summary of the relevant facts. So I see I haven't changed those to 2025, but those will be 2025 now. Again, the summary of relevant facts, I encourage you to use it also if you're unsure, because we would rather have more sources than less sources. So please try to use that space to give us materials, but also to perhaps even highlight insecurities from your side, especially with documents. With documents make our lives a lot easier. Then for the technical aspects, we are working with Google Forms. Please make sure that all the questions are answered. Otherwise, the form will not be submittable. Review the questions so that you know what to expect. Obviously, the more what can I say, seasoned reporters, some of you are with us for a very long time now, will know what to expect. And whenever you stop and save, and I think this is a tip that those seasoned reporters could give to the new ones, whenever you stop and save at a certain moment, you will receive a link. Use the same link, because that will bring you back to the moment where, or at least to the form where you ended. So today, actually, we will be opening the Google Forms. Chris will do that for us. Then on the 16th of January, 2026, the ultimate deadline for the completion will be there for our national reporters. And then in May 2026, as always, around that time of the year, we'll have the publication and a presentation of the observatory's yearbook and the national reports. And again, from my side, thank you very much for collaborating with us. It's an important reporting exercise. I've put the email, by the way, for questions. And I will stop sharing my screen so I can see you actually. Yes, no, and it is a great pleasure for us to work with you. Actually, a few weeks ago, or no, was it last week, Chris? We had our reporter from Slovenia who happened to be in the area and came to us to the office at IBFD.
I think she's online right now.
Yes,
she's
well, that was a great visit, and it was fun to actually see one of our reporters reach out when she was in the area. So again, also that is always a possibility. If you happen to be in Amsterdam, you're more than welcome to stop by, to let us know and stop by IBFD. Because again, the work is highly appreciated. I think we are doing it at a critical time and at an important time, and I get a lot of positive response from both the academic and the practical side on this. So that was it from my side. We can do the Q&A maybe at the end or now, whatever you would prefer.
I mean, either option works. So let's see if there are hands immediately that somebody wants to raise immediately. Otherwise, I can take over and then we can have a final Q&A session. I don't see hands raised, so I take over from you, Sam, and then I will hand over to Philip. And yes, it is too easy to say thank you and thank you every year, but I think it's actually quite important. When Philip and I started this journey many years ago in preparation for the IFA Basel Congress, we felt that there was a need to put this on the global agenda and to do that in a non-judgmental and unbiased way. But then, of course, the empirical evidence that we have gathered with your support, I have counted at least 3 persons among those who are present here who have been with us and have accompanied us on this journey since day one, since the IFA Basel Congress. I think it's actually quite important to say that after so many years, there has been no whatsoever complaint about the fact that we were telling countries what they should do and what they should not do. What matters is that the observatory and it's available open access. It has an enormous stability because we are not changing the questions. We are trying to preserve stability so that we can judge it over time and decades. And we have added last year a section 13. And when we did that, because indeed there was a need to update, and as you might have noticed, we have also added a few specific questions throughout the questionnaire in the standards, because things develop and we have noticed that, and I think we are contributing to that development. Now, last year we were happy about the possibility of having a dialogue with you. And until now, it hasn't been a real dialogue. But the idea of a dialogue is also that we take this opportunity to see if some of you want to point out some global developments that could be monitored in respect of 2025, So in other words, 2025 is not yet over and it's a reporting year. And we normally leave it up to you to just do the finding in your own jurisdiction. But this year, we've also been thinking about nudging some thinking, not sort of influencing your fact finding, because your fact finding should be done exactly in the same way as it has been done for the past years, and also in a way that it's not leading to things that cannot be traced. So remember, your opinion counts, but whatever you say has to be traceable, because our supervisory board says that the scientific nature of the empirical findings only counts if we're able to say that this is not just the opinion of Pasquale Pistone, but it's based on a judgment or something that has been published. So this is actually important also to preserve the the validity of the findings. Now, I want to say that I have been thinking about how to put on the table some topics that have been developing, in particular also in 2025 or shortly before 2025, and that it might be interest to verify with your findings, to verify whether you see some developments in that respect. So I have selected two areas. One of that is what I call the mandatory disclosure area, and the other one is connected to some developments that perhaps Philip might also consider to elaborate on later on. But it's connected with the UN development and the overall sustainability and global South and relevance of human rights in taxation. So, as I said, I'm putting this on the table. The idea is not that you are obliged to say, well, I have evidence that something has happened in my jurisdiction, but I kindly ask you to have a look at whether there have been some developments, because it's actually, in my view, something which might be quite meaningful. So in other words, that we also try to verify whether there have been some developments and whether things that happen are simply not affecting a country or not affecting most countries or affecting most countries. So the first one is connected to what I have generally called mandatory disclosure. Now, this is a kind of label, and we know that mandatory tax disclosure is something that we have basically developed in one country, which Philip usually visits or often spends time in, and then that has developed in the European Union, has developed at the global level through the BEPS project and the global, in connection with the global tax transparency. But in the European Union, we have my computer is crashing, so I do not know if you can.
We can still hear you and see you.
So I have problems, so my computer is crashing. So I kindly ask Sam, in case I can no longer be heard, to send me a message via WhatsApp, because I don't see anything.
We can hear you and we can see you.
Yeah, thank you very much, Chris, and apologies for that, but there are some problems with my laptop. So let me get back to that point. So, the mandatory disclosure developments are significant because they are globally perceived as a way to enhance the global fight against, let's say, abusive tax practices, if we want to use the European terminology, or schemes that are tainted of tax avoidance, if we want to use a different terminology. So I think that from this perspective, it is quite important. I hope you can still hear me. From this perspective, yes, it is quite important to understand that in the European Union, the line of case law on the client-attorney privilege, which has developed from Orde van Vlaamse Balies and has continued with other cases down the line, has clarified that the way in which it is shaped in the European Union and in some countries, it actually raises some issues of protection of data. And we can call it also that fits into the overall area of protection of confidentiality or privacy-related matters. So that is an area where the interest to counter to effectively international tax avoidance or schemes that are tainted of tax avoidance has to face the reality of the protection of data, protection of data and the client attorney privilege. So it clashes on the one hand with the confidentiality in overall terms, and the second matter with what is of fundamental importance for the right to a fair trial. So we are wondering whether there are some relevant developments specifically in the context of balancing the fight against schemes tainted of international tax avoidance and data, and the balancing with the data protection and the client attorney privilege, or more in general terms, the confidentiality with tax advisors, whether there have been some clear developments. Now, those judgments are from the European Union, so the European Court of Justice has indicated that there are such issues. However, this is not just, if we can call it homework, for those who work and do research in the European Union. It's actually perceived at the more global level. Last week at the NIFA LATAM, the IBFD IFA LATAM webinar, we were actually also discussing on the critical issues that have been raised in Mexico and Argentina on that. So it is a global issue, and in my view, it's a reflection of something that happens to the extent that statutes are mostly drafted in the context of governance or global tax governance by tax authorities without a thorough balancing with potential relevant rights. I think it's important to stress that we should consider that the domain where we operate in is not just taxation, but it's also regulated by the law of taxation, which we call tax law. So whenever we have unbalanced instruments, then there might be situations that could be perhaps very efficient from one point of view, but then they undermine the foundations and the foundational values of the different societies. So I thought that this could be one of the two topics that I could put on the table. And as I said, you're not obliged to find something in your jurisdiction, but, this is a topic which might trigger developments. And it would be interesting for us to verify, it's when you have a doctoral thesis, you have a thesis, and you want to verify it empirically or scientifically. So this is also, one opportunity that we would like to use this dialogue for, also because it gives us the possibility to, because you have been corresponding with us for some years, to verify whether some potential trends can be recorded empirically. So that is one out of two that I have selected. Of course, time is limited, and therefore I cannot bring too many points on the table. The second point and the second development is connected with the United Nations. And there the matter is much more complex. And I'm happy that Philip speaks after me so that he can also join me in those comments and also take different views and give you some not entirely matching input in respect of those issues. So there are developments affecting international taxation under the auspices of the UN, which has clearly expressed its intention to be back in the game after some decades, and or at least to take a more leading role than in the past. And that there has been discussion as to whether human rights are relevant or not, or human rights are part of this discussion or not. And I think that the adoption of the terms of reference in December 2024 also reflects this potential issue, whether taxpayers have human rights, or whether we have a dimension of human rights that can be what Philip and I call the collective dimension of human rights, and or the bundled with a individual dimension of human rights. Now, when it comes to the collective dimension of human rights, we should not forget that the Sustainable Development Goals are a relevant framework within which that can operate. However, we should not forget that the Observatory on the Protection of Taxpayers' Rights is very much focused on the individual dimension on human rights. So it's important to perceive whether the developments that are taking place at the level of the United Nations can be reflected in national developments, also affecting the area that is reportable for the Observatory on the Protection of Taxpayers' Rights. I think it's important also because there will be some developments. Those are not. It's not the one on illicit financial flows is not on one of the two early the two protocols on which the United Nations has given priority. But bear in mind that one of the protocols is also dispute settlement, and therefore this is an area where it might be actually quite meaningful to start reporting whether the developments discussed in the framework of the United Nations are regarded as already producing an influence that can be visible also at the level of individual rights of taxpayers in the reported countries. So those were 2 points. As I said, the idea is also that besides reporting, as we have always been doing so far, and we are very grateful to you for all your work that allows us to set up this empirical research, the idea is also that you might consider exploring those areas. And that is something that you can either just link to one of the specific answers to the questions, or also you could include, Sam was referring to the possibility to have a short summary, just to point out something specifically on this and or on the points that Philip will be adding. Now, I have basically presented the 2 points that I wanted to present, but I do not know whether there are hands raised, because I actually don't see hands raised, but I might be wrong, because I don't even see images. I just see the platform as such. I can hear that Sam is now
yes, there are no hands raised.
No hands raised. No.
Okay, so that is pretty much all I wanted to say. So, it seems as if we can continue and having the Q&A at the very end. So it's now 35 minutes past the hour, and I would like to hand over to Philip.
Okay, thanks very much indeed, Pasquale. Good afternoon, everybody from London. It's nice to at least see everybody's names, even if the cameras aren't always on. And thank you very, very much for taking the time to join us. I first of all want to join Sam and Pasquale in thanking everybody for everything they do for the observatory. Really, if people didn't take the time to go through the questionnaire and give us the information, we wouldn't have an observatory. So we are immensely reliant and immensely thankful for everybody who does that. I'd echo what Sam said in saying one of the most interesting things is when there is very specific source information that is provided. So, for example, when there is a change or a clarification of the position in a particular country, whether on a best practice or on a minimum standard, and there is a specific reference to a court decision or to legislation or to a statement from the revenue authority, that not only validates it, but it gives us additional source information that we can look at. So thank you very much indeed for giving us that detailed information. And I think the OPTR is becoming, as a result, a wonderful research tool for those who, whether for academic purposes or practical purposes, want to research what the position is around the world on an issue like professional privilege in tax matters, or audit procedures in tax matters, and you have information and you have sources there. A little note to add to Sam about section 13. I found the answers to section 13, the AI section, particularly interesting. We realized that at this stage, there would be a very large number of countries where there would be a not applicable answer, because either the tax authorities are not using AI, or it isn't clear that they're using it and there aren't any public statements. But we expected that this would be an area where there would be quite rapid developments, and that tax authorities would, if they were not using AI, would soon start doing so. And when they did so, they would probably do so with quite a big fanfare and announcement, and they would be giving information like whether they were going to register the algorithms they use, whether there was going to be human intervention, so that the answers to the questions would become very clear. And we thought this is an area where we would be charting quite a lot of changes year by year, and I'm looking forward to seeing that. Now, very briefly, because I don't want to take too much time away from the Q&A section, just to talk about the UN area. Yes, Pasquale is right that perhaps rather disappointingly, the terms of reference for the UN Framework Convention, which originally made very little reference to taxpayers' rights. There was a debate about this a year ago in New York, and there was a first draft which had a much stronger reference to taxpayers' rights and to human rights, and that got watered down in the context of the discussion, and the final version of the terms of reference makes only a rather disappointing reference. Doesn't mean to say that the issue has gone away, because, for example, for groups like the EU countries, reference to taxpayers' protection is actually something of a red line. And I haven't been following day by day the debates in the drafting committee, but from time to time these issues come back, and they're going to have to come back, so there will be further developments in that area. But I did want to flag up, I guess, probably three matters, one of which is kind of slightly personal to me, but I'll mention each of the three. The first one is not the Framework Convention, but the UN Tax Committee. There's a new membership of the UN Tax Committee just announced about a month or so ago. And as happens when there is a new membership, they, at the first meeting, they decide on the agenda they're going to follow for the next 4 years. And they've invited public input into the formulation of that agenda, and I've put in an input request under my own name, but it's also been supported by various others, that they should set up a working group on taxpayers' rights and human rights. Whether that will be acceptable or not, I do not know. It depends on the other agenda items. It depends upon the 25 members of the committee. If any of you have any influence over any members of the UN Tax Committee, there may be a member from your country, then do please encourage them to support this. I have to say, I'm not massively optimistic that they will take this up, but if they do, and they do set up a subcommittee or a working group on taxpayers' rights and human rights, then their usual practice is to invite volunteers to participate in that work. And certainly, if they take this up, I will certainly make certain that that is notified to people involved in the OPTR, so that those who'd like to volunteer and to participate can do so. As I say, I'm not massively optimistic that they will take this up, but we'll wait and see. That's one point I wanted to mention. A second point, and this is sort of something that I have a personal view on. I've just written an editorial for the journal Intertax, so maybe we'll try to circulate that when it's published, emphasizing that I think we ought to be very precise in our use of terminology in distinguishing between taxpayers' rights and human rights. This is the Observatory on the Protection of Taxpayers' Rights, and the derivation of the taxpayers' rights may very well come from domestic law, constitutional law, administrative law, taxpayers' charters. On the other hand, we have very specifically the application of human rights instruments in the tax field. And that's very specific to the countries, many countries that have ratified human rights instruments, whether they're regional or global, and the interpretation and application of those provisions. And they're different from the application of domestic law, constitutional, domestic tax provisions. So I'm increasingly trying to emphasize that we need to make that distinction between the application of human rights law and the more broader issue of taxpayer protection. Linked to the human rights side, there's some very interesting tax-related material coming out from some of the supervisory committees of certain human rights instruments. For example, the Committee on Economic, Social and Cultural Rights came out with a statement on tax policy for the advancement of economic, social and cultural rights earlier this year. And though we don't specifically cover that at the moment under the observatory, it may well be that some of these tax-related guidances are going to become more important, and we may want to pick those up for future. So that's really just sort of flagging up something that I think we may want to bring in into the future. Now, I hope that's been an interesting little sort of talk about the UN side. I didn't want to go on too long, and I think we've left about a quarter of an hour for Q&A. But again, thank everybody very, very much for all their work on the observatory.
So, Sam, are you going to handle the dialogue and the question time so that...
Of course. Yes. No, anybody who wishes to raise their hands, obviously, this is the time. But this is not only the time, I would say. You can always send us an email as well at the email address you know. I do not at this point see anybody who wishes to ask for clarifications. And obviously, let's this is not a category solely limited to questions. You may also pose a comment about what has been said if you would like us, or if you would like to share an insight with your fellow reporters, that can be done. Or if you think that the developments flagged by our scientific backbone of the project and oversight, that you share those insights, or rather would like to point out something else, obviously feel free to do so now. But it's obviously not mandatory. Yes, Henrik, please.
Thanks. Just a quick clarification. You said something about you had sent out the questionnaires in PDF. I'm not really sure.
No, they will come.
They're going to be sent as soon as this meeting is finishing.
Okay, super. Thanks.
Yeah, we just waited with that because otherwise, obviously, we wouldn't catch all of your attention when you would have the new one. I'm joking. If there's no further, I think, questions or comments, obviously, like I said, our email address is open. Even our office is open, as we have recently seen with our Slovenian contributor coming to visit us. And like I said, we're looking forward to this cycle. It's very interesting to see the follow-up to section 13, to see what has changed, how dynamic this section will be going forward. And from my side, at least, it's always a pleasure to work with you. I see Jennifer Roelveld's raising her hand, so please unmute and yeah.
Hi everybody.
Hiya.
I just have a question for Philip with the human rights and progression that you're talking about. Where this might become very tricky, where it's very sensitive politically, etc. So sometimes it's difficult to give the correct view because of the sensitivity. So all I'm saying, if there are questions on this, that there's an alternative to why an answer cannot be given. I mean, this might happen in other countries as well, but where it is a very extremely sensitive issue, it can be. I'm not saying everything is, but just in some circumstances.
That's, if I might respond to Jennifer. Hello, Jennifer. Nice to see you. Hope to see you in a couple of days' time in person in Lisbon. This is part of the reason why I think it's very important to distinguish between talking about taxpayers' rights and human rights, because what came out of the UN discussion last year was that human rights are often seen in quite a negative way in some countries, and they're seen as a sort of neo-colonial European imposition on countries. I think people need to understand what are the tax implications of human rights obligations that countries have undertaken, and how they can be positively seen, like, for example, obligations of extraterritorial obligations of assistance in order to collect taxes in order to meet economic, social, and cultural commitments that governments have made. On the other hand, taxpayers' rights are part of the constitution of countries. They're given to all taxpayers. They're the sorts of things that you would expect in any tax system. So the right to go to court, the right of confidentiality. And it's exactly because of that sensitivity surrounding the discussion of human rights that I've written this editorial saying, let's be very, very clear. And when we're talking about taxpayers' rights, then there's an overlap, but they're not necessarily the same as human rights. I'm rather glad that we named this observatory, the Observatory on the Practical Protection of Taxpayers' Rights, because I think if we'd have talked about human rights, we would have run into difficult political areas. But yeah, I am very aware of the sensitivity around that there. I'm also very well aware, frankly, of the ignorance of many tax officials and diplomats about what are the tax-related implications of signing up to a human rights instrument. And that's part of the reason why I think the UN Committee of Experts should be providing guidance on this, because take, for example, the extraterritorial application of the International Covenant on Economic, Social and Cultural Rights. Not many people understand that there is that obligation, and virtually nobody understands what it actually means in practice. So some clarification would be really useful. It's kind of outside the area of the observatory at the moment, but it's possible that in the future it might be interesting to look at, to include within the observatory, what has been said by some of the human rights bodies about taxpayers' rights. Long answer to a short question.
Thank you.
And see you in Lisbon.
Thanks a lot. Well, I see Jennifer is shaking her head, so I don't think she's going to Lisbon.
I'm going to cancel my trip then. If you're not going to be there, I'm not going to go.
Logically, I suppose. No, I'm also not going actually. But at least we're seeing each other online. I want to thank everybody for participating, because I don't see a lot of hands being raised anymore. I think I can speak on behalf of everybody to once again thank you. Also, we're looking forward to the results again this year, maybe with even more anticipation than last year, because now we can actually compare the results in respect of section 13, and obviously also the other one, because I think as Philip rightly mentioned, there's a lot going on in this field, and with the developments, indeed, there might even be a section 14 at some point with the implementation of international norms or international law. I see a lot of interesting research being done in that field as well. So I'm glad we're at the forefront. And I think the only thing that rests for me to say is wish you a good day, whichever part of the day you find yourself in. And Chris will send you the questionnaires really quickly after this, and the links to the Google Forms, so we can start another cycle. Obviously, you know where to find us if there's any questions left. But for now, I think a good day to all.